The marital presumption of paternity states that a husband is the father of any child born to his wife during the marriage. Genetic testing can rebut this presumption, but what if genetic testing isn't in the child's best interests? The Kansas Supreme Court considered this in Reese versus Muret. Wade Samuel Waldschmidt, Jr., who went by Sam, married Deloris Hibbs in June of 1970. About 7 months later, Deloris gave birth to a daughter named Heather Reese, formerly Heather Waldschmidt. The birth certificate listed Sam as Heather's father, and Sam treated Heather like his own child. When Sam and Deloris divorced, Deloris was granted custody of Heather, and Sam was granted visitation rights and ordered to pay child support. However, Sam had very little contact with Heather from that point on. Eventually, Sam married Sandra Woodard, allegedly telling her that Heather wasn't actually his child. Years later, in December of 2002, Sam committed suicide. Heather filed a probate action in a Kansas state trial court, which appointed an attorney named William Muret as administrator for Sam's estate. Sandra filed a motion in the probate action, asking the trial court to order genetic testing to determine whether Heather was Sam's biological child. Heather responded by filing a paternity action under the Kansas Parentage Act. Heather asked for a determination that Sam was her presumptive father because she was born during his marriage to her mother. Sandra intervened in the paternity action and filed another motion for genetic testing. The trial court then ordered a Ross hearing, named for the 1989 case In Re Marriage of Ross, to decide whether genetic testing was in Heather's best interests. Concluding that the answer was no, the trial court denied both motions for genetic testing, and Sandra appealed to the Kansas Court of Appeals. The appeals from both denials were then consolidated and transferred to the Kansas Supreme Court for review.